This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Hello and welcome to the 5th season of Murgitroyd's Innovation Talks podcasts. We're delighted you have joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or contact us via Twitter @Murgitroyd. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi there, I'm Wendy Crosby and I am the head of the design team here at Murgitroyd. I generally work out of our Aberdeen office, but I'm currently working from home. I'm pleased to be joined today by my fellow director from our Trademarks group, Eleanor Coates, and we're going to be talking today about the crossover in protection between trademarks and designs and opportunities that companies could have, particularly where you're looking to protect aspects of branding to get additional protection that can be very helpful for them in a commercial market. So hi, Eleanor. Really good to be with you again.
Good to see you as well.
Absolutely. I think, Eleanor, it'd be really good if you could kick off and just give us a brief overview of what trademarks protect, and then I'll do the same with designs and we can go from there.
Okay. Well, trademark protection, it can cover any aspects really of your brand because it can cover the words, your logo, it can cover a 3D shape, it could be letters, and it gives you quite a strong monopoly in that, and it will last for 10 years and can be renewed indefinitely. What's the differences then with the designs, Wendy?
With designs, everything is all about the appearance of the product. So when I think of trademarks, I think about the brand name that someone has chosen for their particular range of products. But with designs, everything is to do with what the product itself looks like. So it could be the shape of the product, or it could even be the colours that are applied to the product. So the pattern that is on your product rather than the shape of your product itself. And the types of things that I was thinking about that you might have a registered design for are the distinctive shape of a drinks bottle, or the pattern that's applied, or even the colours on the packaging of a chocolate bar, for example. So I think of designs as being visual appearance of products, and the product might be the external packaging of the goods, or it might be the goods themselves.
You can get trademark protection for 3D shapes, such as perhaps the shape of a bottle, but it's much harder to get because trademarks have a distinctiveness criteria. And for elements of packaging, particularly ones which are fairly standard, like a bottle shape, while you might get a registration if the bottle shape is particularly unusual and something that the consumer would recognise as being a trademark and having trademark origin meaning, which means that they know it comes from one entity, then if you don't have that level of distinctiveness regarding the shape, then you won't be able to secure trademark registration in the 3D shape alone. And that's probably quite a key difference between designs and trademarks, is that you can get trademark protection for some 3D shapes, but there's much stricter requirements, because the requirements for registering our design aren't nearly as stringent as that, are they, Wendy?
Absolutely. In terms of designs, we would be able to file an application for a bottle shape, for example, and we don't have to have the same requirement for distinctiveness and the link to a particular company or origin for that shape. So we can file design applications for bottle shapes. And I'm thinking particularly for clients such as in the food and drinks industry, where you may have different shapes of whiskey bottles for different products within your range, or alternatively for flavoured water bottles, for example. Again, you may have different shapes in the bottle, and I think designs are particularly helpful in those respects. And that's one of the aspects of difference between designs and trademarks, where, as my understanding for trademarks, you can build up your use of a trademark over time and build up the distinctiveness of that mark before you file your application. application. Whereas with designs, we do have a requirement that the design is new, or I will say nearly new. We have a 12-month grace period between disclosing the design for the first time and still validly filing an application to protect that design. So it can be useful for companies to put out a new range of bottle shape, for example, and if customers really like that particular shape and are giving them good feedback on it, they still have an opportunity to protect the design within that 12-month window.
And what would you classify as disclosing, just for anyone who perhaps isn't as aware of designs as you and I are? What would you say about disclosure? Is that putting it on your own website perhaps, or is it putting it into the shops? How big a disclosure are you required to make?
You're really looking at a disclosure to the public. So if it's on your website, that would certainly count as a disclosure. Equally, if it was out in the shops and already on sale, that would also be a disclosure. If it's something that your company is working with internally and you have memos going around a team, that would not be seen as a disclosure. So it really has to be something that the public, or at least people in the sector of the economy that you work in, would be able to become aware of it.
One of the things that I've often used design registration with my clients, particularly for the launch of new packaging, is the ability as well to defer the publication, because when you file a trademark application, it goes onto the register really within about 2 to 3 days of the application being filed. And particularly in the UK, there's a requirement for intention to use, so you can't really have a third party be filing the trademark. They won't have the intention to use, so it has to be the actual party who's going to use the name. So that can disclose to your competitors, to the wider world, that you're interested in this new name or new packaging. But you can avoid that with designs, can't we?
You certainly can. We can file an application with a request for deferred publication. Normally, the timescale from filing a design application either in Europe or in the UK is very quick. So if we file an application, it will generally be published and registered within a matter of days from filing the application at the relevant office. But if we make a request for deferred publication on filing, then certainly in Europe, we can extend the period of time before there's any publication by up to 30 months from when we file the application. So that can enable you to file your application so that you meet the novelty and new requirement side of things, but not release the designs for publication until you're ready to do so. And that way, competitors won't necessarily be alerted to what your new design is. And that's a way to ensure that you're satisfying the novelty requirement side, but at the same time, you're still in control of when the disclosure is going to happen in terms of your designs.
And it also means that you've got an early filing date against third-party competitors before you launch. I find that to be the most incredibly useful tool when I'm working with marketing departments and they're having a big rebrand coming up on a product. They don't want it to go into the public domain early, but they want to have protection in place for when they launch, which means that sometimes we can't file the trademark application until quite close to launch, because if we're filing a new logo, we can't really file that until it's quite close to the launch, because often launches of large brands for food and drink, you've got magazines such as The Grocer and Retail Week, who they actually monitor for trademark applications. And if they see something like a major brand which is changing its appearance, they will publish an article about it. So using the design to get your protection in early against third parties, having anything coming out to be similar, is really useful tool for those kind of situations.
I think that's one of the major benefits that companies with distinctive branding could be looking at in order to help their timing cycles. Another advantage with deferring the publication of your designs is that if for any reason you don't launch the product, and I'm thinking here, there must have been companies who are undergoing this type of relaunch or rebranding, and the COVID situation happened and suddenly people weren't in shops in the same way. So so perhaps the branding cycle was interrupted. With designs, you can withdraw your design applications in respect of any individual designs if you don't want it to be published, and then refile an application later for that same design. And so long as you didn't have any disclosure, then you still have the opportunity to validly file the application. I think another big advantage from designs that comes from that is that we can file a single application for designs that covers many different individual designs within one application. And typically in Europe, you file a multiple design application and you pay a filing and a publication fee for the first design. And for the next 9 designs in the application, the fees are 50% of design 1. And for any additional designs after that, the fees are only 25% of the fees you paid.
And that's incredibly useful, because certainly when I'm looking at packaging or bottling for my food and drink clients, you're not just looking at protecting one element. The main purpose for when using designs is really trying to stop lookalike products, the kind of products that they're not going to use the trademark, the word mark, because that would be obviously a direct infringement of the trademark, but they're trying to create the look and feel of your perhaps high-end product to give their clients the reassurance that this cheaper version is going to be as good. And so these lookalike products, they can take almost any element. It could be the bottle shape, it could be where you've positioned your logo and maybe a red stripe, or if you've got some bubbles coming up the side, if it's a drinks product, all of these little elements. So I quite often, when I'm filing for this kind of packaging, is I file for the packaging without the word marking at all. I file for it with layers of designs, if you like, to sort of build up the protection. So if it's the fact that we've got colour stripes along the bottom, we might do one with just the colour stripes. If we've then got red tabs at the top, we might do one with the colour stripes and the red tabs, and just build up layers of protection through designs. Because as you say, for a design application covering up to 20 designs, the costs are going down as you file more designs, but the scope of the protection that you then get against third parties goes markedly up by protecting these elements, wouldn't you say?
I think you've really hit the nail on the head there, Eleanor. It's the fact that your competitor is unlikely to take the entire design and recreate that. But in case they do, you can protect that in the application. But if your competitor only takes the red stripes from your example, or only takes the bubbles, then you would have an individual registration that covers only that part of the design, but all within a multiple design application. I also find myself sometimes protecting designs where the first design in the application shows the entirety of the design. And that may be a shoe, for example. It shows everything about the shoe, whether it's the upper, the laces, the sole of the shoe. But design number 2 might only be the sole of the shoe and not the upper. Design number 3 might only be the upper and not the sole. And that gives you the protection where if a competitor takes the whole design and recreates it, they're infringing at least the first design. But if they change the upper in some way and only recreate the sole, they're still infringing design 2. Conversely, if they only take the upper and change the sole, they're still infringing design 3. So you are building walls of protection around your main products that makes it far more difficult for competitors to design around but still keep the same look, feel, appearance of your products and your branding. And I think I've seen some examples where companies will perhaps file 20 or 30 designs related to the same label or packaging of their particular product in order to protect each of these individual elements. And it's then much more difficult for the companies that are looking to provide copycat products to tread between all of the different layers of protection, because they can no longer use a name that's very similar, and now they can't use individual elements of your branding and your designs, which work together, I think, very, very well to give a very strong protection against these types of products.
Yes, it certainly does, because there's nothing worse if you work in marketing to have somebody higher up in your firm find a lookalike product on the shelf and say, why can't we stop this? So it really does assist in that.
Absolutely. And I guess also for these types of clients, rebranding is something that happens on a fairly regular basis. I think we'd spoken previously about clients having different products coming out for different seasons or markets. Would that be correct?
Yes, I mean, certainly there can be, products which are, the main product will stay the same, but the product will be tweaked for the Christmas market. Perhaps they'll have a berry variety, something that's more wintry. So there might be a tweak for that product, and then there'll be a little bit of different branding that perhaps is more festive just for that market. And then likewise, when you come into the summer, they might have a lighter product, another special tweak for that. And so you get quite a few designs. I mean, that's another benefit of the design registration, is that it lasts 5 years initially, and you can renew it for 25 years. But quite often, for some of the packaging products that I would register designs for, the interest will only be for those first 5 years, because quite often the turnaround on packaging is quite often tweaked. I would say 5 years, 7 years at the maximum before they decide that consumer tastes have changed slightly and the Pantone needs to be changed, the image needs to be changed. So it works in quite well with the registered designs.
I can certainly see that. And as you say, I think that's one of the areas where designs work very effectively. Obviously, with trademarks, you have the major advantage that once your trademark is registered, so long as you renew it every 10 years, it will last forever. But as you say, the appearance of the product or the branding tends to be a shorter term marketing strategy than the name that you're actually going to be selling the goods under. I think it would also be helpful just to touch slightly on the infringement side of trademarks and designs, particularly where we're talking about the copycat goods on the shelf in a shop, etc. Am I right in thinking, Eleanor, that to infringe a trademark registration, you have to be using something which is generally confusingly similar to the trademark in question on the same or similar goods for which it was registered?
Yes, although it's not quite so simplistic, because it is confusingly similar for the mark. You're looking at your conceptual similarity, phonetical similarity, and your visual similarity, and for goods or services which are similar. But you also have the issue that you can be infringed if the mark has a reputation on dissimilar goods. So for some marks, they have that added layer of protection due to their reputation. But yeah, in general, it is the likelihood of confusion between the marks and the goods and services. But the infringement position for designs isn't quite the same, isn't it? It's got a little bit of a different test.
It does. That the test in designs is whether or not the alleged infringing design gives the same overall impression as the design is registered. And I tend to think that's a narrower test than typically we have for trademarks. However, the other side of that with designs is that we don't have the limitation that designs are registered for individual classes of goods. So, for example, looking at our food and drinks type clients, if you register the outer shape of a bottle as a design registration, if a competitor makes a drinks mat that has the same outer shape, then that would infringe your design registration in the same way that if they made a keyring that has the same outer bottle shape. So we have a broader number of things that we can look at as falling within the registration scope on the one hand, but probably a more limited definition of what would be infringement, because again, everything really comes down to appearance with designs.
It's interesting you say that though, because one of the points it's worth making as well, we're talking a lot about designs being for 3D shapes, but in fact you can have a registered design for ornamentation, which can be just a logo. And one of the great advantages of that for trademarks, when you're registering your logo or your mark, you have to specify your goods and services. So if your area of interest is clothing or drinks, you're registering it for those goods. But But with designs, because they can cover anything, it means that if your product becomes particularly popular and you actually have people trying to put it on curtains or cushions or lampshades, you can still stop them putting your logo on those types of products, even though it's not covered under your trademark registration, but your design registration would extend that far. The only thing is that you need to remember to file it within 12 months of launching.
And I think also you've made a really good point there, Eleanor. This isn't an either or consideration. It's not a case of you must either file it as a trademark or alternatively protect it as a design. There's absolutely nothing stopping people protecting it in both ways. Both layers of protection give something slightly different and work in slightly different ways, but it gives competitors two hurdles at least to overcome rather than only one if you go down one route or the other.
Yes, definitely. And what I would also say is that if people haven't filed for their logo and can't take advantage of the design protection that we were just talking about so that they can't stop third parties putting it onto other items that they perhaps don't have registered, you can come back to it if you do a redesign or a rebrand. I think that often gets missed is that if you're doing a rebrand or you're tweaking your logo and you're changing it in a material way, then actually that's the perfect time to think about, I'm not just going to refile this as a trademark, I'm also going to take advantage of the design registration protection and have that broader coverage and give your competitors two hurdles. I say competitors, actually it could be any third party. I mean, I've had quite a lot of problems from clients who have popular products and third parties, particularly that they sort of make products out of them, if you like, and sell them on eBay and things like that kind of thing. If you want to have some sort of control of that, your design registration can help enormously.
Absolutely. I mean, that's something that I probably wouldn't have thought about previously, but it is really something for people to bear in mind. I think another area where trademarks and designs can be slightly different is in relation to the prosecution of these applications, particularly with designs, both in the EU and also in the UK. There's no substantive examination of your design application. There's a formalities examination only, and if you meet the requirements for that formalities test, your design will be registered. Can you just give me the position in trademarks on that?
Well, no, in trademarks you will be examined, and it will be examined for distinctiveness, descriptiveness. There's a whole range of grounds that an objection could arise from. And then after you've satisfied the UK IPO or the EU IPO that the mark should be accepted, you've then got an opposition period which will run for 2 or 3 months, which a third party, if they have a prior right, can file opposition. So for a trademark, if you're very lucky, you might get it registered within 3 to 4 months, but it can take, 6 to 8 months, even longer if you get an opposition. So quite often clients don't think about that far ahead when they come to us. And that's another reason where design actually registration, getting that quick design registration through could really assist before launch. Because if you're waiting to get your trademark through before launch, then you might have a little while to wait till that comes through. For design registration, what would the timescale be, would you say? Would you say from filing to getting your registration certificate?
I've had it in as short as 2 days.
Really?
I filed an application and had the registration certificate back. If you file your applications either in the EU or in the UK with a claim to priority, there's generally a 3-month term for filing priority documents to establish the link between your original application and the new application that you're filing. And as soon as you file your priority documents, the case generally goes to registration within a matter of days. So if you're filing an application with no priority claim, then you miss out that step in the middle and the application can be registered very quickly. And one of the very big advantages of that is that often if you're launching your products, and particularly if you have products with a very short shelf life, so like you were saying, Eleanor, a particular branded product for the Christmas market, that's only going to be on the shelves for a short period of time. The advantage that you have through protecting parts of the branding with registered designs is you have the registration in your hand at a time when your product is still on the shelf. So when other parties are perhaps looking to copy individual elements of your branding and put their products out side by side with yours, having having that registration already granted means that we can then take immediate steps to get those products taken off the shelf at a time when your clients' products are still being sold.
And that's right, because for trademark registration, you would have to wait for the trademark to actually be registered before you could actually take action. And particularly as well, I mean, one of the aspects where we get a lot of infringement occurring is on platforms such as Amazon and eBay. You need the registration number to give to Amazon or eBay through their brand owners protect schemes, and you could have your design registration through and use that number to help products from being on those platforms if they are infringing.
And I have used those particular platforms in order to get third-party products taken down from sale very quickly and very effectively. And that's something that clients are more used to seeing side-by-side products now on these types of platforms, but often feel that there's little that they can do if they see something that looks very similar to their products or takes aspects of their branding. And I think designs really come into their own in that respect. And we have successfully helped clients to achieve their aim of getting competitors' goods taken down. And, that's a tremendous benefit to them and a fairly simple system to use. I think also along similar lines, am I right in thinking when you have your trademark registered, you have to keep using the trademark in order to maintain the validity?
You do, but you get a 5-year grace period after registration. You don't have to use it. So, but there's no use provisions for designs.
That's correct. We don't have that same requirement over time. But I think, as you said, we do have to renew every 5 years as opposed to every 10 that you do in trademarks. But that also gives you an opportunity to review whether that design is one that you particularly want to have registered for a further 5 years. It may be that was a product you were only going to put out for a particular marketing exercise. The time period for that may have gone. So you have an opportunity to review your designs on a fairly regular basis to ensure that you're only maintaining the ones that you still need to do.
Yeah, well, this has been a great chat. I mean, I have to say, with my clients, I certainly look to see when they're doing a rebrand or when they're bringing out new products, I ask them to send me in, a picture of the product and see if there is any sort of design work there that perhaps they should think about, protecting. Because I certainly think it is really worthwhile to do to protect both your trademarks and the design element of your packaging, because it gives you such a stronger ground to prevent third parties.
Absolutely. And I think also, just in closing up, as we're approaching the end of 2020 and coming to the end of the transition period for the UK.
You're going to mention Brexit.
For the UK leaving the EU, there is currently a benefit in filing design applications at the EU because with the short prosecution cycle, we're likely still to be able to have design applications registered in advance of the end of the transition period, which means that come January 2021, the UK IPO will automatically create a UK version of the EU design registration without companies having to think about protecting themselves for designs both in the EU and separately in the UK. And I think that's somewhere that our clients could get a big benefit from considering filing designs now in order to not have to think about dual protection come January.
Yes, certainly in trademarks, if you file for your trademark application now, it's unlikely to be registered before the end of the transition period. So while you might be able to maintain a right in the UK, you'd have to pay the application fee for doing so from that EU registration. So there certainly seems to be quite a lot of benefits going forward for designs, and hopefully everyone's learned a little bit of something today and will look more carefully at their branding and their products and have a think about whether design registration might be of use to them.
Absolutely. And I would just encourage anyone who has specific questions to get in touch either with Eleanor or myself through the Murgitroyd website or contact us directly. We're more than happy to deal with any questions. Eleanor, it's been great catching up with you. Hopefully one day soon we'll get to be in the same office again together and can have a coffee in person rather than virtually. But it's been great and I look forward to seeing you soon.
I've enjoyed it. Thank you.
Thanks.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.